Ladies and gentlemen, George Souris, Empire Legal. This week we're coming to you from Bulimba, south of the river in Brisbane. And if you look over here, you can see some wonderful Brisbane icons, some bin chickens right here in the background. Anyway, let's get into it. Today I'm talking to you about divorce and property. So, we're not family lawyers at Empire Legal, but we do work closely with family lawyers to help transact properties that form part of a separation. Divorce, as we all know, is a challenging and emotionally charged experience, and when property ownership is involved, it can be even more complex. In Queensland, understanding your rights, responsibilities, and the legal process around property division is essential for achieving a fair outcome. Okay, so who owns the property? In Queensland, the concept of property ownership in a divorce is not as simple as who is on title. The Family Law Act of 1975 governs property settlements and all assets, whether owned jointly or individually, and they can all be considered in a settlement. So what constitutes property? Well, this includes real estate, bank accounts, shares, superannuation, businesses, vehicles, even liabilities like mortgages and credit cards. When a marriage or de facto relationship ends, a comprehensive assessment of all assets, defining all different items, is usually completed by family lawyers. Our firm specialises in the transfer of real property, so real estate. The process of property settlement. All right, so a property settlement can be negotiated through mutual agreement, mediation, or as a last resort, court proceedings. In Queensland, you've got 12 months from the date of your divorce or 2 years from the end of your de facto relationship to initiate property settlement proceedings. If you miss these timeframes, you have to apply to get permission from the court to file your property application. All right, so there's 4 main parts that occur. Number 1, identify and value the assets. So both parties must fully disclose their assets, liabilities, and financial resources. Number 2, the asset contributions. So the court considers each party's financial, non-financial, and homemaker contributions. Number 3, considering future needs. So factors such as age, health, income, capacity, and responsibilities for children are evaluated. And number 4 is achieve a fair outcome. So the final division must be just and equitable in the eyes of the court. All right, so you might have heard about a binding financial agreement or a consent order. Let's quickly unpack them. So a BFA, binding financial agreement, is a private agreement between both parties that outline how the property will be divided. So BFAs are enforceable but can be challenged if issues like fraud, undue influence, or non-disclosures arise. Usually, a couple that are still on talking terms may opt to get a BFA to save on family lawyer fees, whilst still being able to gain benefit of transfer duty savings and finality. We will explain further below. Keep in mind here that each party should be 100% comfortable with the BFA, as its intention is to be binding. So if you're not sure or you're not comfortable, we suggest you contact a family lawyer before you sign. Alternatively, consent orders are formal court-approved agreements that carry the weight of a court order. They are generally more secure and they're scrutinised for fairness by the court before approval. All right, George, so why are you telling me all this stuff? Transfer duty savings. A significant benefit of formalising property settlements through a BFA or a consent order is the potential for transfer duty exemptions. In Queensland, if your property is transferred between separating spouses due to a court order or an approved BFA, transfer duty may not apply, resulting in substantial savings. Okay, here's a quick real life example. Let's just say a couple have a property for 1.5 million and it's owned 50-50 and one party's buying out the other as part of a BFA or consent order. The savings on the half share transfer of transfer duty alone is $23,975 for the half share, so the person buying the other one out. Keep in mind, you'd need to deduct the cost of the BFA or the consent order. However, the costs associated with either of these will be significantly cheaper than paying the transfer duty. So, as Queensland property experts, we can assist you with your property transfer. We work alongside the family lawyers and the professionals who can assist with the BFAs. If you need recommendations, just get in touch with us and we'll be more than happy to put you in touch with the people that we trust to help you. All right, so whilst you can negotiate a property settlement without legal assistance in a divorce or de facto breakup, seeking professional advice can help you understand your entitlements, navigate complex legal principles, and protect your interests. We suggest that parties that are going through separations get independent legal advice regardless to make sure their interests are protected. Navigating property settlements during a divorce or a breakup is a significant life decision. Seeking advice from experienced property lawyers can help. If you need guidance, reach out to our team for confidential, obligation-free, knowledgeable, professional support. Thanks, guys. Hopefully that helps. Anyone going through this shocking time in their life, a divorce or a de facto split up, you need to protect yourself. Don't just willy-nilly sign a BFA or a consent order because you may not be able to get that reversed. Like, subscribe, and share. We're on the road to 1,000 subscribers. We've got less than 250 to go. If you know anyone that is involved in Queensland property or is just genuinely curious, investors, whatever, send them our page, send them our channel. It's all free content. We just want to help you be armed with the tools to make good decisions. Check out our website for more blogs. We've got over 100. Ladies and gentlemen, please keep in mind that all advice is general in nature and does not constitute legal advice. This is authorised by George Souris Empire Legal, Gold Coast, Queensland, Australia.